Hello, I'm David Shulman. I'm the managing partner of Ginsberg Shulman. I'm here with my partner, senior partner of the firm, Jill Ginsberg. And today we're going to talk a little bit about what people think estate planning is. And it's not just having a single document like a will, but it's really planning for your life and death in case you're incapacitated, and also what happens upon your demise. But a lot of people talk about the death part, but a lot of times they don't really focus on what happens during their lifetime. Jill, what are your thoughts on this?
That part I really agree with you, David. I mean, people will say to me, well, I really don't care what happens after I die, but that's not really the point. And the point is what happens while you're living, and don't you want to make decisions for your own life while you're living? I'm kind of a control freak. I know David is too. And we both want to make sure that our opinions and our decisions are the ones being made, both during our lives and even at end of life. One thing that I think a lot of people don't take into consideration is what happens when you're suffering at the end of your life and there's certain things that can be done, but you don't necessarily want them done. If you're suffering so much and you really want to be put out of your pain, then there's no reason for you to be intubated, no reason for them to keep you artificially alive. But unless you make that decision yourself and tell somebody, it's very difficult for that to happen.
Right.
So,
If you remember, I'm sorry to interrupt.
no, please.
If you remember, the most famous case about this was probably Terry Schiavo, who was in a persistent vegetative state for over a decade. And her husband wanted to let her go. And her parents, who, because of their religion, thought it was against their religion and wanted to keep her alive. And people were arguing, people thought the argument was, what's the right thing? Is it the right thing to keep her connected to machines, or is it the right thing to let her go? But that wasn't really the question. The real question is, what did she want? Because you can't say whether it's right or wrong, because both sides are right and both sides could be wrong. But the question is, what did Terry Schiavo want? And that's what the argument is about. And the reason why they were arguing is because she did not have a living will. And a living will states that if you're in certain conditions, a persistent vegetative state, a terminal condition, or an end stage condition, whether or not you want to be kept alive, or whether or not you want to be prolonged artificially or let go. And I can
And David, that makes you are making the best argument for having a living will. So take a look at the case, that case and the circumstances. In that case, obviously the parents wanted to keep her alive. Why did the husband not want to keep her alive? Okay, well, that's what she really wanted. No, he had a girlfriend and he wanted to get married and get rid of her. So in that case, you definitely want a living will to make sure you're around. So, things like that really show you why.
so both sides had their own.
Absolutely. Both sides had their own agenda. And that's another reason why you want your own document, because you don't know what somebody's agenda is going to be, and that agenda might not be yours. So I think we're both pounding the point home that it's so important for you to have these documents. And these documents are a durable power of attorney, a healthcare surrogate, and a living will. These are what I call life documents. And the reason why they're life documents is because they die upon your death. Once you die, the power of attorney dies with you, so does your healthcare surrogate, and obviously so does your living will. So these aren't death documents, and that's one thing that I don't think people understand.
So that's good. So you brought up two other documents. We just talked about the living will. You talked about the healthcare surrogate and the durable power of attorney. Let's talk a little bit about the designation of healthcare surrogate next, because sometimes it could be connected to the living will. Sometimes I've seen documents where the healthcare surrogate and living will are combined, and sometimes we do them separately. I don't think there's a right or wrong answer. It's just preference. But how does a healthcare surrogate work?
Healthcare surrogate works when you can't make your own decision. A lot of people are like, well, if I can make, well, yeah, if you can make your own decision, you're going to be making your own decision. But if you're unable to make your own decision, for example, very simple, you go in for knee surgery. Okay, that's a fairly simple minor operation, but something happens while you're getting that knee surgery and you need more anesthesia. Well, somebody's got to make that decision for you, and you can't make it for yourself. In that case, You have a healthcare surrogate, and that person's able to make that decision for you.
That's a good point. So many people say, well, I'm only 45. I don't have Alzheimer's. I'm not mentally incapacitated. I don't need a healthcare surrogate. But it's not just those situations. It's like you said, you could go on surgery on your finger or
Wait,
right.
David, I got a great one. You're 18 years old and you're drinking. You're in your frat house and you tripped over the stairs and you're now unconscious and you're in the local hospital. Who's making decisions for you? Because you're not making your own, and neither are your parents, because you're 18 years old. Just a point there.
It's a very good point, and it's a very good idea that once your children, because they're still your children, turn the age 18, it's a good idea for them to get advanced directives like a healthcare surrogate and a living will. And the final one is a durable power of attorney. Now, the durable power of attorney is interesting because the healthcare surrogate can say, these people can only make decisions for me when I become incapacitated or when I'm not able to make their decisions for myself. But the power of attorney is different. How, Jill?
Well, the power of attorney takes effect immediately. So even if you're competent, your power of attorney is still able to act on your behalf. As one of our famous judges calls it, the weapon of mass destruction. Thank you, Judge Spicer, former Judge Spicer, I should say. And it could be a weapon of mass destruction. As a guardianship attorney, I've seen where it has been a weapon of mass destruction. But in 95% of the cases, I've also seen where this document can do so much good and prevent a guardianship, which is, you don't want a guardianship. That's a whole nother video. But, you really need this document, especially if you have people that you do trust in your life, because this is the kind of thing that when you're not able to do stuff, that other people can do it for you.
Right. The power of attorney used to be under Florida law what's known as springing, which is sprang into effect when he became incapacitated.
You're giving me a law firm education here.
But I think it was in 2012 that they changed it. 2011 they changed it because there was an issue that you couldn't tell, that no one wanted to call someone incapacitated. No one wanted to take their risk. A bank would say, I don't know if this person's incapacitated. And the doctor would say, I don't want to do it either because I don't want to get sued. Now, it's important to know that a durable power of attorney, as Jill said, could be a weapon of mass destruction because it gives the person you appoint power to do everything that you could possibly do yourself regarding your bank accounts and your land. But the thing is, sometimes I tell people like that and they say, oh, I don't want one. But I say, look, one, you have to make sure you trust the person. Two, you don't necessarily have to tell them right away. But three, if you don't get it, if you don't have a durable power of attorney and then you do become incapacitated, then you're going to have a guardianship. And a guardianship is a court-ordered process, which actually in our next video, we're going to discuss more about what a guardianship is and how it works and
why you don't want one.
And why you don't
want a durable power of attorney.
But that's why you need these advanced directives to prevent a guardianship. And I think, Jill, that's it for this week. And next week, we'll have our next video on guardianships. Have a good one, everyone.